Hi, I'm Joe Sorge, and welcome to the Family Law Report, where we examine the problems and challenges facing our family law system. This is part 3 in our series with Steve Erickson from Erickson Mediation. In part 1, we covered the inappropriateness of using the adversarial courtroom as a means to settle issues of divorce. In part 2, we discussed the bizarre yet lucrative practice of choosing a custodial parent for the children. In this part 3, we will focus on a different approach to dissolution, mediation. Steve, what's the name of your institute?
We call it Erickson Mediation Institute.
Tell us what you do as a mediator.
In a sense, I serve as a guide dog. I kind of like that analogy. Some client referred to me once. I said I'd make a good guide dog. If you do need a guide dog, the guide dog safely gets you where you're going, but you still decide where you want to go. So if a couple comes in and says, we've got some concerns about the kids, we disagree on the schedule, we think that we can probably reach agreement, but we're not in agreement right now. Oh, I'll help you. I'll help you. Well, they say, how am I going to help you? Well, I'm going to help you talk better. I'm going to ask the questions in a way that is easier for you to answer. I'm going to ask questions that require a cooperative effort rather than a win-lose. Is divorce incredibly difficult? Yeah, it's crazy, crazy times. It's temporary mental illness. I tell them they'll not do anything more difficult ever than in their lifetime get divorced. But you can only get a good result for yourself when you also help the other parent get a good, fair, just result. And I'm going to show you how we can do that in a much easier way by taking the contest away and doing it differently.
How do you take that contest away?
We focus on interest rather than rights and positions. We focus more on the future. Everything that we talk about in the mediation room is about the future. When I was an attorney, everything we talked about was proving something happened in the past or the other person did something wrong in the past.
You know, I imagine it's to an attorney's advantage to give their client an unrealistic assessment of their potential outcome. What do you think?
When people go to a lawyer and say, I'm getting divorced and my spouse makes significantly more than me, say that's the wife. The wife goes to an attorney and the attorney says, well, certainly you're entitled to alimony. We'll get you permanent maintenance. Well, then the husband goes to an attorney and the attorney says, oh, heavens, no, you don't have to pay permanent maintenance. Maybe only a year or two till she gets on her feet. And then, of course, there goes the battle. They're each at different oppositions. They do positional bargaining. So they do positional bargainings based on what they think the outcome's going to be in court or what they think they can get, and that fuels the contest.
How do you handle a client who's been told by a friend or relative that they should hire an attack dog attorney and fight for every last penny?
We get what we call the audience effect. A friend or a well-meaning relative says, oh, you better get a tough attorney. What's this mediation stuff? You just go there and compromise away. You should fight. If you believe what you think you're entitled to, you should fight hard for it. Well, I'm trying to get them to fight hard against the common enemy, not against each other. I'm trying to get them to attack the problem, not each other. You can fight hard, but fight hard for something that you both need. Maybe fight against the IRS for taking all your money. Most people these days have seen friends or colleagues get just burdened and plundered in the divorce system. Really like many of the things you've seen, and they may have even seen the movie. They want to avoid that if they can. And I can say to them, look, these are well-meaning friends that tried to tell you to get some gladiator bulldog attorney, and that's fine. You got a choice. But it doesn't have to be either or. It doesn't have to be either mediation or litigation. Why don't you try mediation?
I know what you're saying, but doesn't the adversarial system favor the dependent spouse? I imagine you have a tougher time with the dependent spouse to choose mediation because they've been told to play up the helpless role in court and maybe win more money.
If I can get them in mediation, I can show them that it doesn't make sense just to advance your case to be dependent or to show that you're not capable. Here's what I think happens. I think in the mediation room, we tend to view people as competent, being able to attack the problem. And in the adversarial system, we sort of view people as incompetent. They're incapable. They can't go out and find work. In the adversarial system, both attorneys spend $2,000, $3,000, $4,000 on employment experts. Wife's employment expert, if she's the one staying at home, her expert says to the court, oh, well, she's not really capable and she needs her computer skills updated. And of course, the husband's expert says, "Oh heaven, she can find a job earning 32,000. All she has to do is go out and apply herself." But when they come in with things like that, I'll say, "Oh, so your attorney said that this, and this is going to happen. Good. If that seems a little bit rich, but go get a written guarantee from him or her." Of course, they aren't going to get a written guarantee. So I say, nobody can guarantee you anything.
Does the law allow people to mediate a divorce and never go to court or appear before a judge?
Apple Computer or Google could decide to dissolve their corporation, and they could work out a plan for buying out all their shareholders or the partners, and they don't need to go get the approval of the court, any of the businesses that anybody has. And yet, family law requires you to go get the approval of the court for your agreements.
But if you need to check in with the fox to get out of the hen house, you've got a problem, right?
Everybody that gets divorced and has kids are required to get the mediation agreement converted to a joint petition, a marital termination agreement, by the findings of facts, the conclusions of law, the order for judgment. There's a number of documents that have to be prepared.
I'm sure the Bar Association loves that, but are there any states that have shown any kind of sanity here and allow people to skip the courtroom and not go in front of a judge?
State of North Dakota. In North Dakota, the courts have said, we'll accept the mediation agreement, and that'll be your divorce decree.
That sounds too logical, almost like Scandinavia, where they don't use lawyers or court to get divorced. My critics have said that the Scandinavian model could never work in the United States. How's it worked out in North Dakota?
They've had just a dramatic success with that.
Have any other states achieved that level of sanity?
We're not there in most other states, but that would probably be the goal down the road.
Well, 3 cheers for North Dakota. Not only do they have a budget surplus and the lowest unemployment rate in the United States, they make good movies like Fargo. And they've taken control away from the Bar Association. I think that's incredible. Give us some advice on how to select a mediator.
First of all, don't let the court appoint the mediator for you. You interview some. Go around and interview some. First thing you want to ask them is, are you a member of the Academy of Professional Family Mediators? You can go to the APFM website, and it's an organization of professional mediators who are dedicated to strong ethics. You can look up our standards of practice, our ethics.
Sorry to interrupt, but it's refreshing to hear an attorney say the word ethics. So are there bad mediators out there, like the kind a judge might appoint?
One of the things you have to worry about is that mediation has become quite lawyerized and very different than what you've been hearing me talk about. For many, many years, I was chair of our family section, and I would get people who would write me emails and letters saying, I went to this mediator and the mediator did this and this and this, and it was just a disaster. I would say, sorry, that person is not a member of the Academy of Professional Mediators. I don't have any authority to sanction them or do anything. You'll have to make a complaint to the Bar Association, because if you go to that person's website, it says they're an aggressive attorney, they'll fight for your rights, and then in the bottom of their webpage it says, and we also do mediations.
Is mediation less expensive than litigation?
Average fees for the completing the mediation was $2,600, $1,300 a piece. You're going to pay $5,000 to an attorney, and all they're going to do is file the paperwork and start the discovery, and everything goes from there. So,
from what I've heard, litigation could cost $15,000 or $20,000 per side.
Sure, easily.
Does it cost that much up there in Minnesota?
Easy. There's an appeals court case. The case said, is it really appropriate to have $140,000 in attorney's fees? They were fighting over who's going to pay them, when the entire marital estate was $82,000. I mean, what's wrong with this picture?
And I hold the judges responsible for that. The judges, if they wanted to, could sanction the attorneys for overworking a case, but they never do. And you and I both know it's because the judges are, getting campaign contributions from those attorneys, or hoping those attorneys will endorse them for their reappointments.
Yeah, and I've encouraged judges to do that. And I think some judges who are trying to reform, there are some judges that feel exactly as I do.
In my opinion, we don't have enough of them.
The judges, I think, should be stronger and more forceful at looking at the abuses and having sanctions and saying, you just did a lot of unnecessary discovery. We're going to require you to pay the other side's attorney's fees to defend that. We need really substantial structural change in our divorce system.
And that's why we made the movie Divorce Court.
I think what you've done is just marvelous, and I commend you for it. Don't lose hope. There are a lot of people out there fighting around the country to reform the system. There are really a lot of people that within the system, even the judges.
Well, if there's a secret Illuminati group out there, let us know about it. We want to join. Well, thanks.
Thanks, Joe. I appreciate it very much. Thanks for getting me on.
Hopefully we can work together to reform the system going forward.
Hope so. Anything I can do to help, call on me. I appreciate it. All right. Bye-bye.
That's the conclusion of this three-part interview with attorney-turned-mediator Steve Erickson of the Erickson Mediation Institute. If you've not seen part one regarding the absurdity of using the adversarial system for family law, check it out. Part two covers the equally destructive business of making parents compete for their children in order to obtain economic stability. They both can be found on Divorce Corp's YouTube channel under the Family Law Report. I'm Joe Sorge, and this is the Family Law Report. Thank you.